This is from the Supreme Court of California dealing with a state case. This is the People versus Wiley Ovieda and deals with search and seizure issues and Second Amendment right to bear arms issues, right to keep arms issues. So we're going to read this and see what the Supreme Court of California had to say. And as you can see, this was issued August the 12th, so just a month ago. So this basically just happened. On June the 17th, 2015, officers were dispatched to defendant's home in Santa Barbara after family members reported he was suicidal and had access to a gun. 5 officers responded and set up a perimeter. They learned the defendant was inside with 2 friends, Trevor Case and his wife, Amber Woolart. Defendant's family was not at the scene, and his roommate was out of town. Officers were able to contact Case, who came out and spoke with them. Case related that there had been in defendant's room, that the 3 had been in defendant's room when defendant began talking about suicide, which he had attempted before. Defendant reached for a pistol near the bed, but Case and Woolart were able to disarm him. Defendant then tried to grab a gun from the bedroom closet and again was restrained. Woolart remained with defendant while Case collected handguns, 2 rifles, and ammunition and put them into the garage. Remaining with the officers, Case called Woolart. She emerged with defendant, who was placed in handcuffs and was searched. Case was very emotional and so was concerned about defendant that he had alerted defendant's family members, prompting them to call the police. Officers Colbert and Bruce entered the home to do a protective sweep to secure the premises and to make sure no one else was inside who might be armed, injured, or in need of aid. Officer Colbert testified that based on experience, each situation is different and requires consideration of multiple possible factors, though safety of persons is paramount. He and Bruce were unsure if all parties were accounted for, did not have a clear picture of what caused the situation, and felt duty bound to secure the premises and to make sure no people inside were injured or in need of assistance. All right, so far, I as a lawyer am thinking about exigent circumstances. I'm thinking about community caretaking exceptions that would apply to the Fourth Amendment. So they have a report about an actual situation ongoing that may require their immediate attention. So under traditional Fourth Amendment law, I'd be thinking, okay, this sounds like a valid reason to go in and do some kind of search, some kind of need to make sure that everyone is there, everyone's accounted for, there's not an ongoing threat, and so forth and so on. But let's see how the facts develop in terms of the Fourth Amendment interests. The 2 officers entered with guns drawn because there was talk of multiple weapons in the house, and the situation was emotional and dynamic. They moved slowly through the house, checking rooms and closets where people in need of help might be found. Colbert had no intention to search for criminal conduct and had no reason to believe that any other criminal conduct was afoot. After entering and during the sweep, Colbert noted an overwhelming strong odor of marijuana and numerous related items to marijuana cultivation and consecrated cannabis production. All right, so right there, I'm thinking about basically what we would call the plain view exception. So if you have a reason to be in a place legally, and you can see, hear, smell, observe other things in plain view, basically readily apparent. You don't need to open drawers, you don't need to look anywhere. But if you can observe things that are criminal, plain view applies. You don't need a search warrant because you can see it from where you would be lawfully. So, assuming they have the basis to be there lawfully, if they smell marijuana, that might give them additional basis to search for crime related to that. Of course, this is California, and the marijuana laws in California are much different than they are anywhere else. So that would be an additional factor as to the legality or not of the marijuana that we would have to factor into the analysis. But let's continue. Colbert also saw ammunition, a gun case, scales, and large industrial drying ovens with ducts leading to the garage. On cross-examination, Colbert acknowledged the case had said that guns had been taken away from the defendant and that he, only Woolart, and defendant had been in the house. Case never said that any domestic violence was involved or that anyone else was inside. Colbert had no information that there was anyone else in the home. Well, that being true, I still think in broad terms that there's a ability to search where people might be found, because the idea that they might be lying is not exactly outside the realm of possibility. We know that there's an ongoing situation we know there's an ongoing threat, and we might want to search and see if there's other people there. Seems reasonable under an exigency circumstance, at least on initial impression, but let's continue. Officer Garcia also testified and largely confirmed Cobert's testimony. Garcia spoke to Case once he came outside. Case was distraught and tearful during the conversation. Brought outside by Woolert, defendant was searched and handcuffed. He denied being suicidal or having any guns. The on-scene officers collectively decided to conduct a safety sweep. On cross-examination, Garcia conceded officers had no specific information that led them to believe that someone else was inside. They were told defendant's roommate was in Washington State. Case did not know if there are other guns in the house besides those that had been taken to the garage. More officers were called to the scene. No search warrant was ever obtained. Ultimately, large quantities of guns, ammunition, and drug-producing equipment were removed from the house and the garage. The recovered weaponry included a submachine gun and a rifle with a long-range scope. Defendant was charged with manufacturing a controlled substance, importing an assault weapon, and possessing a silencer and a short-barreled rifle. He moved to suppress evidence found in the home. After the suppression hearing, neither officer testified that they asked defendants permission to either check for others or that they questioned the veracity of Case and Woolart. They mentioned no noise or movement in the house or garage creating concern others might be involved or there's anything amiss there. They are not asked what, if anything, they intended to do with the defendant or whether he be allowed to return the residence. They did not rely on the possibility to justify the need for the protective sweep. The prosecution bases its case on the community caretaking exception, not exigency circumstances. Okay, so fair enough. So we have basically moved from a two-universe theory into a one-universe theory. So as I was stating before, we had, at least in my view, two things that came to mind. Exigent circumstances, there's an ongoing needed threat, and community caretaking. There is a situation that requires our attention, and we can go tend to that. And obviously, they're tested differently. So the exigency circumstance didn't seem to apply because there was no evidence of anyone that would be hurt beyond what, once we'd secured the two people and they both said that they were all in there. We apparently don't doubt that. We didn't hear anything to contradict it. So exigency circumstances may or may not apply. Personally, as a prosecutor, I don't know that I'd necessarily drop that theory. I think there might be enough here for exigency circumstances, but the government in this case dropped that theory. And so the only issue is the issue of community caretaking. Question from Jabberwocky69 is, does plain view always apply regardless of the reasons to search? Well, first of all, I just simply note that words like always and never are not really great things to do in the law because always and never is pretty much never true. But as a general proposition, plain view typically applies regardless of the reasons for the search. If you have a right to be lawfully where you are and you can observe it just in plain view, then typically they would provide it. So there you go. Anyway, so we're continuing just on the community caretaking exception. Okay. The prosecution based its case on community caretaking exception, not exigency circumstances. The court denied the motion, except the officer's testimony regarding what they knew, what they were concerned about, and what they didn't know. The court reasoned that the officers were not required to accept Case's word that he had removed the firearms, reasonable, and noted they would be subject to criticism if something untoward had occurred because they did not conduct a sweep for others who might pose a danger or needed assistance. Fair enough. I think that's reasonable in my view. After pleading guilty to the manufacturing count and to possession of the assault weapon, defendant was placed on probation. A divided court of appeal upheld the search under the community caretaking exception. So the trial court said it's okay, the court of appeal says it's okay, and now we're before the Supreme Court of California. Fair enough. Let's discuss the law, right? Both the federal and state constitutions prohibit unreasonable search and seizure. In California, issues relating to suppression of evidence derived from governmental searches and seizures are reviewed under federal constitutional standards. And by that they mean that under law, the federal Fourth Amendment sets a floor, not a ceiling. States can give more rights than the federal Constitution does, but according to this, the California doesn't do that. They just simply apply the federal standard, and that's certainly their right. Continuing, the ultimate touchstone of the Fourth Amendment is reasonableness. The physical entry of the home is the chief evil against which the wording of the Fourth Amendment is directed. Very true, the home is special. It is a cardinal principle that searches conducted outside judicial process without prior approval by a judge or magistrate are per se unreasonable under the Fourth Amendment, subject only to a typically few established and well delineated exceptions. Yeah, fair enough. They're unreasonable on their face unless there's another exception that applies. The burden is on the people to prove the exception applies. We defer to the trial court's factual findings, express or implied, when provided by substantial evidence. That's the typical standard. The trial court gets to determine the facts. In determining whether on the facts the search or seizure was reasonable, we exercise our independent judgment. That's an issue of law. Trial court, you get to tell us what the facts are. We, the appeal court, will tell you what the law is. That's typical, it's true. A long recognized exception to the warrant requirement exists where exigent circumstances make necessary the conduct of a warrantless search. The exigent circumstances describes an emergency situation requiring swift action to prevent imminent danger to life or serious damage to property or to forestall imminent escape of a suspect or destruction if et mis. There's no ready litmus test. In other words, there's no one test, there's no one standard. There's no ready litmus test for determining whether such circumstances exist, and in each case, the claim of an extraordinary situation must be measured by the facts known to the officers. Fair enough. It's a dynamic, ongoing situation, and it's exigent based on the facts as it applies. So there's no one rule, there's no one test. Basically, we have to look at the totality of circumstances to determine, is there an emergency? Fair enough. The High Court has recognized exigent circumstances may exist where there's probable cause to believe a crime has been committed, but an emergency leaves police insufficient time to seek a warrant. If there's time to get the warrant, get the warrant. It is also found exigency when entry or search appears reasonably necessary to render emergency aid, whether or not a crime might be involved. Yeah, just because there's not a crime, if someone's dying, on a floor somewhere, you can bust down the door in order to help them not die. Seems reasonable. We don't question the right of the police to respond to emergency situations. Numerous state and federal cases have recognized the Fourth Amendment does not bar police officers from making warrantless entries and searches when they reasonably believe a person is within need of immediate aid. The need to protect or preserve life or avoid serious injury is justification for what would otherwise be illegal absent the exigency or the emergency. And police may seize evidence that's in plain view during the course of their legitimate activities. As I was saying, if you have a legal reason to be there, anything that you can observe plainly on its face is fair game. So if you have a legal reason to be there, plain view typically applies. Accordingly, law enforcement officers may enter a home without a warrant to render emergency aid to injured occupant or to protect an occupant from imminent injury. Yep. Thus, the exigent circumstances exception applies to situations requiring prompt police action. These situations may arise when officers are responding to or investigating criminal activity and where there's a need for an emergency aid, even if unrelated to criminal conduct. Criminality is not necessarily required. Not for the least of reasons, criminality is maybe not apparent. But again, if someone's dying on a floor somewhere, we want people to help them. Makes sense, right? Examples of exigent circumstances in prior cases include hot pursuit of a fleeing suspect. I will note here that hot pursuit is typically considered as a separate exception, but if you want to roll it into exigency, fine. And by hot pursuit, we just mean that we're chasing the felon as they're running away. A great case I saw one time on this is the police were chasing a felon. For some reason, the felon ran through a guy's home. The police followed through the home. The felon got away. But unfortunately, the guy who was in the home at the time, the homeowner, was basically cutting up drugs for use. And that's valid because they had a valid reason to be there, chasing the felon. So they lost their felon, but they got the guy making drugs in his house. Unfortunate, but that's the way it goes sometimes. Preventing imminent destruction of evidence, fighting fire, intervening in a physical altercation or crime in progress, or providing emergency help. Lower federal courts have also recognized a warrantless entry in response to an actively suicidal person may be justified to prevent the injury. The threat an individual poses to himself may create an exigency that makes the need of law enforcement so compelling a warrantless entry is objectively reasonable under the Fourth Amendment. If the officers here were lawfully inside defendant's home, they could seize contraband in plain sight. They could also rely on what they have seen to secure a warrant to conduct a more extensive search. This case turns on whether the initial entry of the officers was lawful. This case does not fall into any recognized scenario describing exigent circumstances, and the Attorney General does not argue otherwise, nor does the Attorney General rely on the need for the protective sweep. While it's undisputed that the defendant was suicidal when the officers arrived at the home, he subsequently came out and was restrained. The officers cited concerns that unnamed persons might be in the house and there might be victims or loaded firearms inside. While these concerns are obviously important, the people elicited no testimony to show the officers reasonably believed that they were actually in play. Okay, fair enough. As a general rule, the reasonableness of an officer's conduct is dependent upon the existence of facts available to him at the moment of a search or seizure, which would warrant a man of reasonable caution and belief to take an action taken as appropriate. And in determining whether the officer acted reasonably, due weight must not be given to any unparticularized suspicion or hunches, but rather reasonable inferences which he's entitled to draw from facts in light of experience. In other words, he must be able to prove to specific and articulable facts from which he concluded the action was necessary. So mere speculation is not enough. We have to be able to rely on something. Okay. Here, the officers point to no such facts. If they existed, the prosecution failed to elicit them. Indeed, the facts in the record point to the contrary. The officers responded to a dispatch that the defendant was suicidal. Case, defendant's friend, told the officers that he, his wife, and defendant were the only people in the house, and defendant had been disarmed. All three were outside before the officers entered. Although the officers were not required to take Case at his word, the only immediate danger reported was that the defendant might be a harm to himself. But before the entry, defendant was in handcuffs and under police control. There are no reports shot had been fired, the defendant was a threat to anyone else, or there were any other victims in the house. The officers mentioned no sounds or possible movement in the house, or any suspicious behavior by a defendant or his friends during initial interaction. Furthermore, possession of legal firearms as a home is generally lawful. See, for example, District of Columbia v. Heller. And their presence in an apparently empty home does not, without more, constitute an exigent circumstance. There's no indication the firearms were accessible to others or they posed a threat to the officers or public. The people cite no authority, and we have found none, that when an exigency was found to exist based on facts similar to those here. And again, I think this emphasizes the importance of the fact-specific inquiry, because my general gut impression off the top is, okay, this sounds like it might fall within exigency circumstances. But see how carefully the court is laying out the facts and how critical the facts are? All they had testimony was that there were three people. No one disputed that there were only three people. The person who was suicidal was arrested outside the home. They are in handcuffs. There's no longer an exigent circumstance. The exigency had been removed. There was no sounds coming from inside, no bumps, no sounds of distress, no one crying, there was no evidence that suggested any other exigency. No shots had been fired that we might have to go investigate that. So based on these specific facts, the exigency had been removed because the exigency was the suicidal person and that person was in handcuffs. So there was no exigency at this point, and goes to show the importance of the fact-specific inquiry. And I really, really like this thorough analysis and shows why there's no per se rules, because you have to just look at the totality of circumstances. Did the police have a reason to go into the house? Probably not, under exigency. So let's look at community caretaking and see if that applies. Even in the absence of exigency, both the trial court and the Court of Appeal majority concluded the warrantless entry here was justified under the so-called community caretaking exception. We begin our discussion with People v. Ray, where the lead opinion of this court recognized a non-emergency community caretaking exception permitting residential entry. For reasons discussed below, we conclude no such exception exists, and the lead opinion was wrong to create one. So basically, they are saying quite clearly, there is a lower court that said there's this thing called the community caretaking exception. And the Supreme Court of California is saying, no, there's not. Doesn't exist. We are just saying it flat out does not exist. The Supreme Court of California gets to do that. They're a higher court. And they say, yeah, this lower court that said there's a thing, is not a thing. It doesn't exist. Poof, goodbye. And so, hey, they can do that. They say there's no such exception. No problem. As we discuss in further detail, the United States Supreme Court has articulated the concept of community caretaking, but only in the context of vehicle searches. And that's exactly true. There have been, I think, 3 U.S. Supreme Court cases on point. All 3 cases dealt with vehicles, and I believe at least one of them there was dicta, which is non-binding, but it's basically a superfluous discussion. But superfluous discussion from the Supreme Court is taken fairly seriously, as you might understand. But there was superfluous discussion basically saying that this probably should be questioned more in the home. So yeah, the U.S. Supreme Court has said this is a thing that exists in vehicles, but the home is special. Let's continue on. In Ray, someone called the police and reported that the neighbor's front door had been open all day and it's shambles inside. Officers responded and confirmed the door was open and the front room appeared to be ransacked as though someone went through it. Officers knocked and announced their presence but received no reply. They then entered to conduct a security check to see if anyone might be injured, disabled, or unable to obtain help. The house was empty, but officers found drugs and cash in plain view. They left and obtained a search warrant. Now, to my initial mind, this is the kind of thing where you might want to create a community caretaking exception. We arrive at the home, the door is open, it appears ransacked. There's evidence that there might be a problem. Perhaps we want the police to go in and investigate the problem, but let's see what the court has to say about it. The lead opinion garnered 3 votes to amplify the community caretaking exception. It drew a distinction between exigent circumstances and community caretaking. And fair enough, I think there is a distinction because there's not exigency here. I think that much is plain. An exigency circumstance analysis is appropriate, it said, when officers are searching for evidence or perpetrators of a crime in response to an emergency. For the exception to apply, officers must have probable cause for the search or seizure and show that because of the circumstance, there's no time to obtain the warrant. The community caretaking exception, the lead opinion maintained, applies when officers are not involved in crime seeking or crime solving, but instead are providing some kind of aid unrelated to a criminal investigation. And fair enough, just because you arrive at a door and see the door open and the house in disarray is not immediately apparent that there is a crime. People have a right to have their door open. People have a right to keep their house in disarray. So it's not immediately apparent that there is a crime. It's not immediately apparent that there's distress. Maybe we should investigate, maybe we should not. Let's carry on. The lead opinion then asserted the community caretaking exception arises in 2 situations: entry to render emergency aid and entry to preserve life or property. While conceptually these situations seem to substantially overlap, the lead opinion analyzed them under different standards. Okay. When relying on the need to render emergency aid, the people must demonstrate specific, articulable facts indicating the need for swift action to prevent imminent danger to life or serious damage to property. The lead opinion concluded that people failed to do so on the record before it. Accordingly, it rejected the reliance on the need to render emergency aid. Fair enough. We've created a standard. You need to prove this. You haven't proven it. No problem. However, the lead opinion held that different facets of community caretaking required a less stringent showing that could justify entry. It pronounced, under the community caretaking exception, circumstances short of perceived emergency may justify a warrantless entry, including protection of property, as where the police reasonably believe the premises have been or are being burglarized. According to the lead opinion, under the less demanding aspect of the community caretaking exception, the question is, given known facts, would a prudent and reasonable officer have perceived the need to act in proper discharge of his or her community caretaking functions? The always popular reasonable man test. Would a reasonable person, reasonably educated, perceive the need to undergo this role? The lead opinion concluded, the facts before us precisely illustrate one facet of the law enforcement community caretaking exception. It reasoned that while the facts known to the officers may not have established exigent circumstances or apparent need to render emergency aid, and fair enough, I don't think they do, the warranted further inquiry to resolve the possibility that someone inside required assistance or property needed protection. In such circumstances, entering the premises was the only practical means of determining whether there was anyone inside of need of assistance or the property needed protection. As noted, the lead opinion did not garner a majority. Neither its holding nor its reasoning constitute binding precedent. A separate three-justice concurrence agreed that the result of the entry was proper. It did not embrace the lead opinion in the rationale. Instead, it urged under exigent circumstances analysis, entry was permitted. So the court said that is proper, but they disagreed as to the rationale. We have defined community caretaking exception to include emergency situation requiring swift action to prevent imminent danger to life or serious damage to property. The action must be prompted by the motive of preserving life or property and must reasonably appear to the actor necessary for that purpose. The concurring justices determined the facts in re supported warrantless entry without the need to expand available warrant exceptions. Exigent circumstances exist because the officers had reasonable cause to believe a burglary was in process or a burglary had been committed and there are persons inside in need of assistance. Okay. The lone dissent firmly rejected the suggestion that we should create a broad new exception to the Fourth Amendment protection against warrantless searches, permitting police officers to enter a residence even when there's no threat to occupants, merely as part of community caretaking exception. Such exceptions threaten to swallow the rule that absent such a showing of true necessity, the constitutional guarantee to right to security and privacy in one's homes must prevail. I strongly disagree with the assumption that warrantless search of residence under non-exigent circumstances can be justified on the paternalistic premises that we are from the government and we are here to help you. That's a nice touch there with that line. What was it? That's a Reagan quote, right? The Reagan said the most scary words are "We're from the government and we're here to help." So that's a paraphrase of a Reagan quote. Very nice trick. The dissent concluded that the circumstances did not warrant a reasonable belief entry was necessary to secure or preserve life or property. To the extent officers believed they were called upon to preserve the community caretaking function, it would suffice to shut the door. Okay, so you can see the Court of Appeals is struggling with this issue. It's like, look, maybe there's a reason to enter this, but if we enter this, what kind of exception is this opening? Is this opening of floodgates? Is this going to create a rule that's going to swallow the Fourth Amendment? So you can see the Court of Appeals playing with this idea, and they couldn't even get a majority for this idea because of the controversial nature of it. They ultimately said that it was valid. They couldn't agree why, community caretaking or exigency, and you have one dissent that says, it's not valid under any theory because we don't want to swallow the rule. Okay. In recognizing a community caretaking exception, the lead opinion discerned support for People versus Roberts and People versus Hill. In Roberts, a car potentially involved in a commercial burglary was registered to a woman living in a San Francisco apartment. The apartment manager told officers the defendant had also lived in the same apartment and had not worked often and was sickly. Officers knocked on the door and received no response, but heard several moans or groans that sounded as though a person was in distress, and the manager let them in at the request. Officers found no one, but they discovered a radio stolen in the burglary. Based on this, they obtained a search warrant. Roberts upheld the entry. The court initially noted that the trial judge found the officers reasonably believed that someone inside the apartment was in distress and in need of assistance, and they entered for the purpose of giving aid. While cautioning that the privilege to enter render aid does not, of course, justify a search of the premises for some other purpose, the court held that once the police were inside, they could seize stolen items in plain view. Recognizing the court found on substantial evidence the entry was lawful for the purpose of rendering aid, and the officers were justified in entering the room of the apartment to look for distress. The radio was in plain sight and fit the description of property known by the officers to be stolen. I would wonder, like, how specific is this description? Because a radio looks like a radio, but I guess it could be really specific in some detail. Carrying on, Under those circumstances, there appears to be no reason in law or common sense why one of the officers could not pick up the radio and examine it for the purpose of dispelling or confirming the suspicion. Plain view observations made from a position in which officers otherwise have the right do not constitute a search, citing a U.S. Supreme Court case to that point, and I would tend to agree with that. In Hill, two men arrived at a home to buy drugs. Inside, they were accosted by two assailants. One of the two men was shot and taken by a witness to a hospital where he died. The assailants fled. Officers were sent to the scene and received no response when they announced their presence. They entered the house and found evidence related to the shooting in plain view. Although rejecting the claim of the entry was justified by hot pursuit, Hill upheld the search because the circumstances were sufficiently exigent so as to justify an immediate entry and search. We note that immediately after the police learned of the searching on Huanta Street, the officers were dispatched to investigate. They only knew the shooting had very recently occurred and one person had suffered from serious wounds, had been brought to a hospital. The officers found fresh blood stains on a fence and porch of Huanta Street murder site and on an automobile parked outside. They also observed through a porch window what appeared to be bloodstains on a floor inside the house. Although only one casualty had thus far been reported, others may have been injured and may have been abandoned on the premises. There was no response when the officers knocked and announced themselves, and in entering the premises was the only practical means of determining whether anyone inside was in need of assistance. If there was, delay in obtaining the search warrant could have resulted in an unnecessary loss of life. Under circumstances, it was reasonable for officers to believe the shooting may have resulted in other casualties in addition to that reported by the police, and that immediate entry was necessary to render aid to anyone in distress. The police therefore have borne their duty of demonstrating the existence of a circumstance which justifies warrantless entry. The line between a mere hunch and a reasonable suspicion based on articulable facts can be a fine one, like all lines in law, right? When you really get down to it, there's this uncertainty principle. But the line does exist. If all is required is the possibility that someone in the house might require aid, any officer on patrol might urge that people in their home often need help, and an officer enter to make sure no assistance was required. As Justice Perrin observed in his dissent, ignorance of a fact without more does not raise suspicion of its existence. Right, this is kind of a Russell teapot kind of thing, right? Roberts and Hill are example of this kinds of articulable fact that can support a reasonable suspicion to enter to deal with an emergency. So here are two circumstances on which there were articulable facts. We saw blood through the window. We saw this thing. We heard moans. We heard that kind of thing. We heard something. We saw something. These are articulable facts. Fair enough. The Ray lead opinion failed to acknowledge that while Roberts and Hill did involve entry to render potential aid, they both involved emergency situations based on articulable facts. Neither case suggested warrantless entry to render non-emergency aid would have been warranted. As Robert Court observed, necessity often justifies an action which would otherwise constitute a trespass, which incidentally is true for both civilians and non-civilians. Necessity is a reason to break a law that otherwise wouldn't exist. Like if you came upon a home that was burning and you could see like someone lying on the floor in this burning house, it would be necessary and legal for you to bust down the door and to take the person. Now, if you bust down the door and take the person normally that would be like breaking and entering. It would be kidnapping because you're moving the person from place to place. But the law, fortunately, is not that stupid. You have the ability under necessity to engage in these kinds of things because, I can't call the police and have them do it because the fire's ongoing and this person's going to die. It has to happen right now. And what's true for the police is true for civilians and vice versa. And so that's exactly what they're talking about. Similarly, Hill concluded an exigency existed and immediate entry was necessary to render aid in anyone of distress. The presence necessary emphasized by both cases is incompatible with a non-emergency condition. If it's not an emergency, you can't do it. If it is an emergency, you can do it. Aside from the Court of Appeal below, no published California case after Ray has applied the community caretaking exception outside the context of a vehicle inventory. At least 2 cases have concluded no substantial evidence existed to support the community caretaking search. This doctrine did not justify a police stop where police believed a passenger may have been ill. And another case held a belief that where there's a marijuana ripoff at a residence was unsupported by substantial evidence and warrantless entry was not excused. So we're looking for a line between a hunch, and we're also looking for a line between a non-urgent emergency situation and an emergency situation. The need to render emergency aid is well recognized part of exigent circumstances exception, but has always been required that articulable facts support a reasonable belief that an emergency exists. The Ray lead opinion, having found no such facts were established, created a less demanding exception. It purported to permit a warrantless entry if some kind of police assistance might be rendered, but the need was merely hypothetical. The Ray's lead opinion diluted exception was not supported by our prior jurisprudence. The circumstances it describes as community caretaking do not involve non-emergency situations at all. Rather, it describes situations that could be emergencies but lack sufficient articulable facts to reasonably suggest an emergency exists. It suggested that entry was justified to resolve the possible that someone inside required emergency assistance or property need protection. If officers had articulable facts to believe someone inside needed emergency aid or crime was ongoing, they could enter based on those exigent circumstances. The lead opinion suggested that entry is justified to explore the possibility those facts exist dilutes the appropriate standard for exigency. Indeed, such a suggestion is incompatible with our later clarification, turning to another case, that although police do not need ironclad proof of likely serious life-threatening injury to invoke the emergency aid exception, officers must pose and possess an objectively reasonable basis for believing an occupant was seriously injured or there was a threat of such injury. The line falls between the mere incoherent possibility an emergency could exist and articulable facts that make it reasonable, even if uncertainty, to prove an emergency does exist. So you see here, the California Supreme Court is very clearly putting a line between exigent circumstances and this community caretaking. It says, look, if you have reasonable, articulable, reasonable facts that say there's some kind of ongoing emergency, that's one thing. That's exigency. We all recognize exigency, but mere hunches aren't going to do. Mere speculation isn't going to do. You need something you have to point to. You have to point to something that is objective, that's reasonable, that a reasonable person could conclude from. And if you can, then you have exigency. If you can't, you have this community caretaking thing, but that doesn't exist because we're the California Supreme Court, and we can say it doesn't exist. The officers here surmise that there may have been others in the home who required aid or posed a threat if allowed access to unsecured firearms. Those could be exigent circumstances justifying warrantless entry, but the objective facts that elevate speculation to reasonable suspicion were not present or were not articulated. Yeah, they were speculating. This is speculation. There's nothing to go on. There's no facts. If you had heard something, if any one of them had said there are other people, if you had reports there are other people, if you had heard if there had been shots fired, if there was something, some reason, then you could have done that, but there was nothing here. Further, even though the officers here could not articulate facts pointing to an emergency, they are not without recourse. If officers reasonably believed defendant was a danger to himself or others due to mental disorder, they could have temporarily taken him into custody for mental health evaluation. So we're talking about, well, what could the officers do? Well, they could have seized the person who was suicidal. That would have been possible. And if they had done so, they could have obtained a warrant for the seizure of the defendant's firearms. Yeah, if he's being held for mental health evaluation, then perhaps they could have gotten a search warrant related to that. Fair enough. But it's not an emergency. There's time for a court to look it over. There's time for a court to get a search warrant. And so you had time here, and you didn't take that, so that's different. United States Supreme Court precedents. Scant high precedent supports the Ray Lead opinion. Indeed, the United States Supreme Court has never applied the concept of a community caretaking search outside the context of an automobile inventory. In the case of Katie versus Dombrowski was an off-duty policeman involved in a single-car accident. He was arrested for drunk driving and was taken to the hospital, while his car was towed to the garage. Dombrowski was required to carry his service revolver at all times, but he did not have it on him when he was arrested. An officer went to the garage to search for the gun, saw blood and other evidence in the car that linked Dombrowski to a murder. Question from Jabberwocky: does California have red flag gun seizure? I believe the answer to that question is yes, but even in that case of red flag gun seizure, unless I'm mistaken, that still requires some kind of court order. You still have to go to court and get a judge to sign off on it, if I'm not mistaken. And so again, that would be different than exigency and would not apply here. In upholding the search, Caddy took great pains to distinguish between a home and vehicle searches because of extensive regulations on motor vehicles and traffic, and because also the frequency with which a vehicle can become disabled or involved in an accident on public highways. The extent of public police-citizen conduct involving automobiles will be substantially greater than police conduct involving a home or office. Local police officers, unlike federal officers, frequently investigate vehicle accidents for which there's no claim of criminal liability and engage in what, for want of a better term, may be described as a community caretaking function, totally divorced from detection, investigation, or acquisition of evidence related to a violation of a criminal statute. So we're basically, under Fourth Amendment law, talking about the vehicle exception. Vehicles are different because they move and they transport things, and the law typically treats them as different, and so that's what's going on here. The court observed the constitutional difference between searches of and seizures from homes and similar structures and from vehicles stems both from the ambulatory, the movement character of the vehicles, and from the fact that extensive and often non-criminal conduct with automobiles will bring local officers into plain view of evidence, fruits, or instrumentalities of crime or contraband. Yeah, fair enough. The police have about a bajillion reasons they might interact with your car. They might be ticketing it because it's, illegally parked. They might be looking at it because it has a broken headlight. They might be pulling you over for whatever. And they look through the back window and, oh my God, there is evidence of a murder. This happens with what I would describe as somewhat disturbing regularity. The amount of times that the police, for what is a very routine traffic stop, find evidence of major crimes is somewhat shocking. How many pages is this? I'm not sure because this particular version is not paginated. So I don't know how many pages it is, but we are almost done. It's not that long, all things considered, but it is very detailed. Let's see. Katie emphasized the police had exercised a form of custody or control over the car, and the search of the trunk to retrieve the revolver was a standard procedure in the police department to protect the public from the possibility a revolver would fall into untrained or perhaps malicious hands. Katie concluded that the search was reasonable under the circumstances. The court's previous recognition of a distinction between motor vehicles and dwelling places leads us to conclude that this type of caretaking search conducted here, a vehicle that was neither in custody nor in premises of the owner and had been placed into where it was by virtue of lawful police action, was not unreasonable solely because a warrant had not been obtained, whereas here the trunk of an automobile in which the officer reasonably believed to contain a gun was vulnerable to intrusion by vandals, we hold the search was not unreasonable within the meaning of the Fourth Amendment. The High Court later applied this case to the reasoning upholding inventory searches of impounded cars and the containers therein. So when your car is towed and impounded, the police can do what's called an inventory search. As its name suggests, they can inventory the items. The rationale for that is that they want to, the rationale is if you have an interest in this too as a person whose car is towed. You want obviously all the things that are in your car to be in your car when and if you get them back. And so if you're a law-abiding person, and there are things in your car, and those things are stolen while they're in the police impound lot or otherwise, you'd like there to be a record of that. So the idea of an inventory search has long been protected. Now, as undergoing this inventory search, if they happen to find, the bloody clothes, you're going to have to answer some questions as you might inspect. But again, this all goes back down to the idea that vehicles are different and homes are different. Katie and its progeny did not create a generalized exception to the warrant requirement for non-emergency community caretaking functions, much less apply such an exception to the search of homes. Homes are different. Katie does not suggest community caretaking rationale alone could justify the search there. Instead, the court emphasized police had taken constructive possession of the car in question and searched it pursuant to standardized procedure. Katie and other cases all involved searches of vehicles in police custody. The caretaking function existed only during the security of items in those vehicles. None of the rationales justifying these results in Katie and subsequent cases apply here. The search involved a home where the privacy expectations are most heightened. The home is different. The Fourth Amendment recognizes and reflects the recognition of the framers that certain enclaves should be free from arbitrary government interference, and the court has since the enactment of the Fourth Amendment has stressed. The overriding respect for the sanctity of the home has been embedded in our traditions since the origins of the Republic. The court has repeatedly acknowledged that vehicles and homes are afforded different levels of constitutional protection. Fair enough. The rationales are completely different. The idea of privacy in your vehicle is a little strange because vehicles move down public highways. Anyone can see them. Anyone can look into them. Anyone can, the idea of, it passes by. You drive on your way to work and you pass by 1,000 people every day who have some interest in looking at your car. That doesn't really apply to the home. The rationales are totally different. Outside the inventory search context, the High Court has taken a dim view of warrantless entries in absence of the exigency. In Mincy, the court rejected a blanket murder scene exception to a warrant requirement. It acknowledged that when the police come upon the scene of a homicide, they may take a prompt warrantless search of the area to see if there are other victims or the killer is still in the premises. Yet Mincy reasoned that a warrantless search must be strictly construed and circumscribed by the exigency which justified its initiation, and simply cannot be contended that a search was justified by any emergency threatening life or limb. So if you come upon a scene of a homicide, you are still limited on what you can do without a warrant. Now, that would give you the ability to get a warrant pretty readily, one would imagine, but still, you have to go get the warrant. All the person in Mincy's apartment had been located before the investigating homicide officers arrived and began their search. And a 4-day search that included opening a dresser drawer and ripping up carpets can hardly be rationalized in terms of legitimate concerns that justify an emergency search. I would tend to agree. Similarly, the court observed that a burning building, of course, creates an exigency that justifies a warrantless entry by fire officials decidedly, or for that matter, probably just about anyone else. Although I wouldn't necessarily recommend it, if there's a building burning, you can probably break down the door to put out the fire. I would not recommend this for many, many rational reasons, but as far as law is concerned, it's probably lawful. Moreover, once in the building, officials need no warrant to remain for a reasonable time to investigate the cause of the blaze after it's been extinguished. Where, however, reasonable expectations of privacy remain in fire-damaged property, additional investigations begun after the fire has been extinguished and the fire and police officials have left the scene generally must be in pursuit of a warrant of the identification of new exigency. Fair enough. These cases established that an emergency might initially justify a warrantless entry or search, but once the exigency has been abated and the premises vacated, a subsequently warrant entry or search is not justified. Yeah, you did have a rationale, and now that rationale is gone, and you need a different rationale. This approach is consistent with the High Court's well-established principle. Searches and seizures inside a man's home without a warrant are per se unreasonable in the absence of one of the well-defined exigent circumstances. The court noted, in terms that apply equally to seizure of property and persons, the Fourth Amendment has drawn a firm line at the entrance to the home. The home is special. Absent exigent circumstances, that threshold may not reasonably cross without a warrant. High court decisions have emphasized that exceptions to a warrant requirement are few in number and carefully delineated. Citation and the police bear a heavy burden when attempting to demonstrate an urgent need that must justify warrantless searches or arrested. Indeed, the court has only recognized a few such emergency conditions. The home is special. The Attorney General urges at length that officers here were not motivated by a desire to investigate a crime, but rather to ensure public safety or render aid to potential victims. However, the United States Supreme Court has made clear that officers' subjective intent plays no role in the Fourth Amendment inquiry. Yeah, that is true, and that's kind of one of these situations with the good come the sweet, with the bad, but with the bitter come the bad. Um, the subjective intent or subjective purpose of a police is and always is irrelevant. And this comes a lot in the context of vehicle stops, particularly if you were of a mind that you were stopped for perhaps illegal reasons. Perhaps you were profiled, for example. But the Supreme Court has long ruled that you cannot go into the subjective intent. The question is objective. The question is, did the police stop you for an objective reason? Can they point to some violation of law for which they stopped you? Their subjective motivation is irrelevant. And here it's subjectively irrelevant too. So in the context of a person being stopped because they're profiled, well, we're all very kind of not thrilled about that perhaps, because maybe we should want to go into the officer's mind and ask, hey, what was your reason for doing this? But, that swings both ways. The officers here said, hey, we had a really, really good subjective reason. And so the court is saying, well, we don't care if you had a subjectively bad reason for doing something, so why should we care if you have a subjectively good reason for doing something? Your subjective intent is irrelevant. So in the context of stopping a car for profiling reasons, that's not good. In the context of this immediate case, where we're not worried about the police's subjective motivation, it's good. We don't care if you had a good motive. Your motive is irrelevant. All we care about is what's objectively true. So it's nice that this reality of law has swung in a way that is favorable to citizens. I like that quite a lot. The officers here may have acted with the very best of intentions, but an officer's venal motives will generally not undermine an otherwise valid search. A benign intent cannot save an invalid one. I want to read that again because that is a very good summary of the law. Just as an officer's venal motives, their evil motives, will not generally undermine an otherwise valid search, a benign intent cannot save an invalid one. The subjective reasons are relevant. Whether you have an evil motive or a good motive, our question is objective. I like that quite a lot. I like it that it's even, at least. Let me be clear, I like that it's even nature. The Attorney General likens the present search to a home safety inspection and relies on Camara versus Municipal Court. The argument falters at the threshold. Unlike Camara, the entry and search were not routine periodic inspections, nor did they have a long history of judicial and public acceptance, because the public interest demands all dangerous conditions be evaluated and abated. Administrative safety inspections and similar entries are quite different from entry by police officers with guns drawn. Further, even Camara required a warrant to be secured if a person refused inspectors access, unless prompt entry was required by an emergency situation. So even in the context of an administrative search or administrative purpose, if a person refuses entry, you still have to get a warrant. Camara neither supports the Attorney General argument nor the reasoning for the Ray lead opinion. In sum, the community caretaking exception asserted in the absence of an exigency is not one of the carefully delineated exceptions to the residential warrant requirement recognized by the U.S. Supreme Court. To date, the court has only recognized this exception in vehicles. The judgment for the Court of Appeals is reversed. The matter is remanded with directions that the case be returned to the trial court to permit defendants to withdraw his guilty plea, and the court enter an order granting defendants suppression motion. So the guilty plea can be withdrawn, the suppression motion will be granted. Hypothetically, this person could be tried again. It wouldn't be double jeopardy, but now that the evidence has been suppressed, what's left for the state? I don't know enough about the facts to know if there's anything else that the government could rely on, but at least based on an initial read, it looks like this guy will be set free, because I don't think there's anything left, but that's really good. And so that is the conclusion of this case. There was a question asked from Smurf Bearer Barbecue. So the risk of a tangent, if there's a profiling but no objective reason for the action to be covered, but there's profiling and no objective reason can be presented that it's not covered. Wow, let me read that again because I didn't quite get the question. So the risk of a tangent, if there is profiling but no objective reason for action, it's covered. If there's profiling but no objective reason, then the search is invalid because there's no objective reason. The profiling is irrelevant under the law. So if there's no objective reason, then you can't do the search. But if there's profiling, yeah, yeah. If there is, yeah, exactly. If there is objective reason, that's the question. So the profiling is irrelevant because motive is irrelevant. The only question is the objective reason. So if you are of a mind to pull over people of a particular race on cars, then you might then you can probably do so as long as you have some objective reason, and that's the way the law is written. We don't look at the subjective reason. We look at what the objective reasons are. Did you have an objective reason? Fortunately or unfortunately, in the case of automobiles, it's fairly trivial to come up with a reason, because you follow a person for any length of time, and they're going to do something in violation of the traffic law. It's pretty hard not to. But that's the way the law reads. We don't look at the motive, despite whatever. But it goes the same way here. Just because you had a really, really good reason, your motive was pure, you were on the side of angels, doesn't matter. With the bitter comes the sweet. Your motive cannot justify it, nor can your motive unjustify it. Motive is irrelevant. So that is the end of this case. I think super, super interesting. And I have been persuaded by the court. That's why I read these things with you. I think that the court makes a very, very solid case. First of all, the U.S. Supreme Court, I agree with them totally, has not held this to the home. So that's perfectly reasonable. They haven't explicitly said otherwise, though, either. So I think it's open for the California court to go either way they want. And, they said there's no community caretaking exception. So fair enough. Manitoba Misanthrope points out very correctly that violating a traffic law does not give the right to conduct a search, but they can look for things in plain sight. Absolutely 100% true. And if as part of plain search they find evidence, that may justify further searching. But those are the rules as they typically apply.